Welcome to Washington Legal Foundation and TechFreedom's Tech in the Courts program. My name is Glenn Lammy. I am Executive Director and Vice President for Legal Studies for the Washington Legal Foundation. For those of you that are not familiar with the foundation, we are in our 48th year of free enterprise advocacy and education through litigation, amicus briefs, and regulatory comments, and through various types of education, including this type of program. We do publications as well. We have a blog. And if any of you want to learn more about us, you can go to WLF.org. So this is the ninth program that we've done with TechFreedom in this Tech in the Court series. We really appreciate our partnership with our friends at TechFreedom. TechFreedom, for those of you not familiar, is a nonprofit, nonpartisan technology think tank launched in 2011. It seeks to advance public policy that makes experimentation, entrepreneurship, and investment possible, and thus unleashes the ultimate resource, human ingenuity. I'm pleased to introduce one half of our conversation today, Corbin Barthold, Internet Policy Counsel and Director of Appellate Litigation at TechFreedom. He writes on tech legal, regulatory, and social issues for a wide range of outlets, including City Journal, The Bulwark, Reason, Lawfare, TechDirt, and The Daily Beast. Corbin also hosts the Tech Policy Podcast, which this is a crossover event with the Tech Policy Podcast, so it'll be released as an audio program through that. And he previously served as one of my colleagues at Washington Legal Foundation as a senior litigation counsel. We are recording this program today, just so you know. If you are by chance watching this as a recording on YouTube, please like and subscribe to that. And with that, I will turn the proceedings over to Corbin.
Thank you, Glenn. For about 10 seconds, it looked like an AI moratorium was going to pass through Congress. This provision would have barred states from passing AI-specific laws while leaving general protections like fraud statutes untouched. The moratorium was quietly approved by the House. Then people noticed it, and controversy ensued. Then the thing was narrowed. Then Steve Bannon started yelling about it. Then it was killed in the Senate by a vote of 99-1. And here we are, left to wonder what the heck just happened and what the heck happens next. AI remains a hot topic in the states. With the moratorium dead for now, what new state legislation can we expect? What's good? What's bad? What's ugly? Is Congress really done? Is there a path to federal legislation, whether in the form of preemption or an AI framework or both? And by the way, have you noticed that people are kind of freaked out? Have you seen how AI polls with the public? Not great, Bob. How do we change that? Welcome to a new installment of the Tech in the Courts webinar series, brought to you by Washington Legal Foundation and TechFreedom. This is also an episode of the Tech Policy Podcast. Welcome to those of you there. I'm Corbin Barthold. I'm joined today by the perfect person to answer all my burning questions. Matt Perault is the head of AI policy at Andreessen Horowitz. Matt, how are you?
I'm doing great. It's great to be on. I'm a longtime listener, big fan of the Tech Freedom podcast, so it's great to be on with you guys today.
Good to have you on. You are overdue for the Tech Policy Podcast. Welcome. The AI moratorium. What the hell happened? As we were discussing before we started recording, the 101 of what this wasn't too complicated. I feel like I've captured it somewhat in my one sentence description. But the dynamics behind the sudden rise and fall of this really was, I think, earth-shaking is not too strong a word in the policy world, at least. What were the dynamics that led to that rise and that fall?
Yeah, so maybe we should start just by talking about what led to the idea that maybe a moratorium or something of that sort was needed. Our firm, Andreessen Horowitz, is really focused on not the big tech side of the tech ecosystem, but the little tech side. So these are startups of a range of different sizes. But one thing that's been interesting for me since I joined the firm back in November is just seeing how small some of these companies are. Like some of them don't have a general counsel. So most of them don't have a head of policy. So these are small companies. And where we have seen the bulk of AI legislating regulation to date hasn't been at the federal level, it's been at the state level. So I stopped counting at 1,000, but at some point in the course of the past set of state legislative sessions, there were over 1,000 bills that had been introduced governing in AI in different forms. Some of those I think are positive, some of them are benign, but a range of them I think would have really imposed significant compliance costs on little tech companies. They would have made it harder, I think, for little tech companies to compete by doing things like requiring them to conduct audits or impact assessments or make really complicated legal determinations or produce certain kinds of information through transparency mandates. And that struck us, and I think lots of different organizations that are focused on startup competitiveness, as problematic. And so one of the ways that lawmakers might think about addressing that is thinking, what's a proper role for state governments and what's a proper role for the federal government? So you know this better than I do. You're a great legal mind. The Constitution does not give the federal government and state governments the exact same role. So lots of people have said the federal government's not acting in this area. We need states to take action, and that's not quite true because states can't do exactly what Congress can do. So the fact that Congress isn't acting doesn't mean states could do whatever they want. And so we had concerns about state action that would really make it harder for little tech companies to offer products nationally, not just products that can exist in California or New York or Texas or Florida, but products that can exist across state lines without requiring them to jump through a lot of loopholes or bear a lot of regulatory burdens in order to do it. And so thinking about those proper roles, basically the federal government would take the lead in regulating governing a national market in AI, focused on AI development. So like, what are the kinds of things that you would need to be required to do? What would you be able to do if you're developing an AI market? That principally should be the job of Congress. Then there's a question of what would states do? And the idea, I think, in that concept is not that states would do nothing, but that states would do the things that they traditionally do, which is police harmful use within their borders. That framework of like, there's an important role for the federal government to play, and there's an important role for the states to play was, as you're suggesting, totally lost in the debate about this moratorium. I think it was like extremely well-intentioned. Again, I think it was like aimed at addressing this problem that I think startups were facing. But the way that it was received was really, I think, and you can just start by the name, a moratorium, it was received as if it was telling states to not act. And so I think there were sort of two things that led to the political challenges that you were describing. One was states want a role in AI policy, and the Constitution gives them a role, and it's understandable that if you're a state legislator, if you're a state attorney general, if you're a state governor, that you want to play a role in governing this technology, and you should. The second component, I think, and this was also part of the discussion around the moratorium, is that, and you alluded to it, there are things that people are concerned about. They're concerned that AI will be used in a way that will harm them. And so the idea, which I think wasn't actually accurate, I don't think it was aligned with what the text of the moratorium actually said or would have done, but the idea that this is going to prevent lawmakers, and the lawmakers who have shown an ability to pass legislation, principally in our country, have been state lawmakers. The idea that it's going to be hard for states to address those potential harms was something that I think people really were concerned about.
I am still grappling with why this thing died its flaming death. I'm directionally sympathetic with the notion of keeping states from piling into this and creating a 50-state patchwork and going straight after the models and having 20 states put in EU-style risk assessment reports and all that. But a lot about this was badly done. I think 10 years was ambitious would be one way to put it. A little nuts would be another. If you take seriously how fast the very people building this say it's moving, that's an eternity in the evolution of this technology. The failure on you might say, marketing side to make clear that you still can't commit fraud. You still can't discriminate. There's all these laws of general application on the book, and that was a loss in maybe a PR sense. Was this something that went down because it wasn't done right and there could be something done better than next time? Or was this a revelation that those who are promoting AI actually face significant headwinds, significant fears, significant pushback, and maybe need to go back to the drawing board about how they frame this entire debate?
Yeah, I mean, I don't know about doing it differently, but there was certainly a thread that was lost here. Like I am on our policy team. I'm the head of AI policy at Andreessen Horowitz. I'm not on the government affairs team, and what that really means is like I'm in the policy world. I'm not in the political world, and there's a lot that I don't understand about the politics. There ended up being a discussion here that I think bore no relationship to the actual substance of the proposal. So there was a large exemption in the proposal for generally applicable law, and I think this is what you're alluding to. That means if a lawmaker a state attorney general wanted to enforce a law related to consumer protection, but where AI was used in a way that violated a state consumer protection law, that was not a problem under the moratorium. The same would go for state civil rights law. The same would go for state criminal law. The requirement was that it was generally applicable. And I think probably you and I would agree that that actually is consistent with a best practice in policymaking, that you don't want to enact policies that are technology specific. It could be that we're sitting here 5 years from today and we're saying states passed all these AI laws, but now the technology has moved beyond the definition of AI in those laws. And so those laws are basically null and void for what we're facing in the future. So generally it's viewed as best practice to have laws that target harms no matter what the underlying tool is that creates those harms. And I think the moratorium would have accounted for that. That reality, if we agree on that reality was not the nature of the discussion. The nature of the discussion was this prevents state lawmakers from passing laws and enforcing laws that are related to kid safety and forces and misuse of a likeness and all of these different potential harms that, again, as I read the text of it, I didn't quite understand. And I can't give you an answer, unfortunately, to like why that was the reaction by some corners of the political universe. But again, I think it might have come from this idea that that there was a perception that what was happening here was a desire to tell states to do nothing. And that, I think, is a really important perception to avoid with lawmakers who, you run to be part of a state legislature. You presumably are doing that to try to enact policy within your jurisdiction that's consistent with what your mandate is. And again, consistent with the Constitution, and to be told that you're not going to be able to do that. I can understand why that would be really deeply frustrating. And so, at least from a narrative perspective, letting that be the perception, I think is problematic. Could it have been corrected by different action at the outset, or like different action at some point in that process? I'm not sure about that.
I am going to have probably more questions for you on vibes and public perception, whether you like it or not. But for the moment, let's turn then to where the action is going to be once again for the foreseeable future. The states. There is so much out there. I will start sort of open, and maybe we'll then go down into specifics. Can you give us a sense of the landscape? What are the most notable kinds? The 1,000 number, it's fair, but it's also not entirely fair. Very few of those are actually going to pass. I'm assuming there are only certain categories that are really setting off alarm bells for you. So what are the biggest moving pieces that you are watching in the states?
Yeah, right. There are alarm bells. There are also things that are positive. I think it's important to talk about those as well. Like there are things that are focused on state capacity building and studying more about the issue, which everyone always thinks that studying is like a throwaway thing. But I think this is a new technology. We should learn more about it. We should learn about it with an eye toward informing smart future policymaking. So I think those kinds of steps are really good. There are, I think, tools around policy experimentation that are really valuable that states are doing. Like I've, for a long time, really liked the regulatory sandbox model. That's another thing that has been politicized in ways that I don't fully understand. But the idea that you'd give room to companies and the government to experiment, and that you learn things in the process of that experimentation that would then inform future policymaking seems generally like a positive one. And states have really been leaders in thinking about regulatory sandbox concepts. So I don't want to, I said 1,000 as if that just was like maybe a signal of something that was problematic. It's not necessarily. There's lots of stuff that's happening at the state level that's positive. There are some things that are problematic, and the set of things that we view are problematic are the things that are focused on regulating model development, just the process of science and innovation related to building a model. So that's like how you build a car engine, as opposed to like selling a car, or what the product of a car looks like. And in our view, when you are taxing that underlying model development by requiring impact assessments and certain transparency requirements and requiring audits and all of those things that might be burdensome, you're just slowing the process of development. You are literally taxing development. You're going to get less development. And you're actually not even targeting harmful use. So you said at the outset, people are scared about this thing. So to the extent there are fears, I think the way to address fears is to give people some comfort that if they're harmed from AI, that there will be recourse. I think if we were starting from a blank slate and you were like, I think AI is going to do harmful things to me, what should we do? I don't think the first thing we would say is like, let's develop an impact assessment model so that you'd write about all the potential things that might or might not happen, and maybe you'd take some corrective action to address them. I think that is probably like not what we would say is the first order of business to ensure that you're protected. I think what we would say is, let's contemplate the potential ways you might be harmed and ensure that the law can take those into account and punish perpetrators when they're engaged in harmful activity. And so that's the main set of state proposals that we think are problematic. And again, like the orientation, I started my tech policy career at Facebook. That was a different part of the tech ecosystem. The thing that I'm thinking about is like, if you are a 4-person company and you're trying to do this extraordinarily impossible, daunting thing, which is like compete with Microsoft or compete with OpenAI, compete with Meta. The process of making just development harder is going to make it even less likely that in that almost impossible endeavor that you're engaged with, that you're going to be able to succeed. And from our perspective, that's the thing that's really deeply problematic.
I want to come right at you on this dichotomy between models and outcomes.
Yeah.
In a lot of other contexts, I'd be the first to come out here, and I've mentioned many times on the show, Frank Easterbrook's cyberspace and the law of the horse. We don't need a law of the horse. We need a law for if the horse trespasses on another person's property or you hit somebody with your horse. And that is true in my mind for everything from shovels to vehicles.
Mm-hmm.
Totally with you. What's potentially different here is we're dealing with a truly revolutionary piece of technology that even if you just listen to the people who are building it, they are saying all kinds of bananas things that really come up to the line of, oh yeah, hey, we're building God. We're building this alien intelligence. Mark Zuckerberg is quite explicit. I want to build super intelligence. I want to build this thing that is much smarter than we are. And so when we say, oh, it's a problem to go at the models, they're these small companies. Won't someone think of the small companies? You're going to get a sympathetic ear from me. But what I think a lot of people are going to hear is akin to, hey, we've got this great stride forward in nuclear technology. And now people can build nuclear reactors in their garage. And now startups can build nuclear reactors. It's going to be great. Just wait until something goes wrong. And if there's a harm, we can deal with it then. There's just this disconnect between how effective I find that argument in a lot of other contexts and how it is likely to hit here. I think it's very reasonable for someone to say, great in all these other contexts, Matt, but this AI thing is actually, if we just listen to the people building it, it's different. Why is it not sensible to put transparency in? It doesn't have to be super onerous. Some of these laws, it's just have a safety plan, like write something down that is your plan so that we know that you're thinking about it, or have basic transparency, have whistleblower protections. That seems like a powerful argument. I mean, what say you?
Yeah, so I don't think most of those things are lightweight. They're often described as lightweight. I think felt lightweight at certain points in my career because, again, when you're at a larger company, some of these companies have 1,000-person legal teams, and you can deploy 5 people to work on a really good safety plan, work with the government on that to make sure that the things that you've included are responsive to government needs, address potential issues that arise to minimize your liability. I don't think startups have that luxury. Like you are trying to get a product to market, and the chances that you fail are extremely high, and diverting what, again, for a big company would be fairly easy, but for a small company might be significant resources, I think is a meaningful diversion. I mean, different people will have different ideas about that, but I think it's a meaningful diversion. The second question is, well, if there's that cost associated with it, maybe it's a cost that we want to bear, right? Because like the benefits of doing that are so high. My view is the benefits are not zero, but are close to zero. It won't stop bad actors. I think even for good actors are those kinds of contemplate the future, predict potential risk. Are they really likely to identify new risk that you wouldn't already identify, that you wouldn't take into account because of deterrent effects of existing law? I think the answer is no. And again, I think the whole exercise results in us taking our eye off the ball from what we can do in the short run to really protect people, like the thing that we really can do, which is ensuring that the laws that we have really are fit for purpose. And my guess is they are to a great extent, but not perfectly. So like, can we make sure that fraud statutes will take into account for the range of use cases that may involve AI? Same with, federal and state civil rights laws. Same with various different bodies of state and federal criminal law. So I think it's not just that we think that focusing on development is challenging for little tech. It's that we think it also is not a very good mechanism for protecting people. I think it's conceivable that 3 years from now, we have a whole bunch of use cases that we've identified as problematic, and some of those existing law can take into account some of them, but it might not take into account others. And so, yeah, maybe there are other things that we need to do in the future to address some of the potential harms. But I don't think the sort of minority report approach of like, we're going to try to conduct a level of surveillance to anticipate what is going to happen in the future and to prevent harmful activity before it occurs. My guess is that it's going to have a significant more cost than benefits.
As you work with startups, gonna reveal my ignorance here a bit. Are startups in a position where they're building models that you're worried they're going to trip straight into these laws, some of which have tried to have high thresholds? I know SB 1047, that was the idea, whatever it is, $100 million. And I know that can go wrong in all kinds of ways of, is it cumulative? Is it one model? But for sake of argument, let's pretend we can get some kind of high threshold right.
Sorry, can I ask you about that threshold?
Yeah.
Is what? Because there are different types of thresholds. So do you mean like compute power?
That's exactly my point, is that how much money you're spending on it, what are the amount of compute you're using. I don't think we're going to get a satisfactory answer as we sit here of what we'd want that to be.
Yeah.
I'm sort of cabining. Let's say we could iteratively get us all somewhere comfortable that it's a high threshold. That's it. From a startup's perspective, is the concern that as the models get cheaper or more efficient, they will drift into those red lines? Or is it that by kneecapping the frontier firms, you are hindering the ability of the startup to get acquired or to use the tech that is coming down from those firms? I'm just trying to get my head around what precisely the concern is from a little tech perspective.
Yeah, it's great. So that's a good question. So there are a couple different components of it. One is, we've heard in some contexts, people will say this piece of legislation is only designed to cover this small number of companies. And from our perspective, I think that's intended to be a good thing. Like you're going to be exempted. From our perspective, the vision is that the frontier is competitive, not that the frontier is a monopoly situation or an oligopoly situation, that it's just a small number of firms. We want the frontier to be a place that startups can aspire to compete at that level, that startups don't feel a barrier to get there. And so it's sort of a different vision of what competitiveness in AI looks like. The second component is like, this is why I asked you this earlier, what is the threshold? And from our standpoint, any any development-oriented threshold is problematic. And I wish I had the exact data to give to you, and I don't. I don't today. But if you look at like the first draft of the EU AI Act, I think it was 10 to the 23 floating point operations was the threshold, or it might have been 10 to the maybe it was 10 to the 22. And the recent guidance that they came out raised it. So it was one up. It was like 10 to 23 if it had been 10 to the 22, or 10 to the 24 if it had been 10 to the 23. And I think the Biden executive order was a level above that. And at the time they issued the executive order, I think there were 3 or 5 companies that were covered, or something in that range. And I think today I heard that there are like more than 30 would have been covered by the executive order. And so the rate of development of the technology is high. And from our standpoint, it's not a very good proxy for the things that you'd want to take account of. Like there are models with that would hit a quote unquote high flops threshold that would be totally benign, and there are models that would fall far below that could be problematic. And so our view is to really focus on the application layer, as opposed to the development layer. And there is at least one threshold that corresponds to that, which is revenue. Like to be positive in the revenue category, you need to have brought a model into a product market in some form and actually be getting revenue for it. So the new draft of SB 53, the bill in California, actually includes a revenue threshold. We think that's a positive development because, again, like at that point, you are in the application phase, you're selling a product into the market, and you're getting revenue, which means that arguably some percentage of that revenue could go to pay for compliance costs. There's obviously like a question about what should that threshold be set at? Like where does it sort of appropriately delineate between small and large companies? But I think generally the idea of a revenue-based threshold is a positive one.
Even determining how much of that revenue is coming specifically from your AI model seems like it could be a problem.
You could do it that way, or you could. I mean, yeah, that's something that I think I need to give more thought to. But I think you could also make it not specifically related to an AI model. So you could imagine like a very large company that has significant revenues and then starts to build an AI product. I think there's an argument to be made by that large company then, because of its overall revenues, could divert some of those revenues to compliance costs associated with its AI product. And so maybe it doesn't have to be AI specific.
If you're Mira Murati and you can get $2 billion in VC funding to build your superintelligence, and you're very explicit that you're not going to come out with a product until you have superintelligence, I feel like this doesn't really work from the perspective of sort of the doomers, I suppose. But
I don't know that that's the case. I mean, again, so my last job at Facebook was head of the global competition policy team, and we were told a lot when I was in that world that we wanted more competitive tech markets. Like we wanted them to be as competitive as possible. That someone's gotten a lot of VC funding to support the creation of an AI product, I don't think tells you that much about their ability to bear significant compliance costs. Like I was saying before,
I'm just saying, like, where might the scary models be coming from?
Yeah, but for better or worse, there are significant barriers to entry in AI. Right, there are like significant data costs. There are like operational data issues. There are data costs. There are compute costs. There's there's been a lot of discussion recently about the cost of talent in AI. If you are trying to get an AI company off the ground, you are facing significant hurdles. I think if you really want a competitive market, the thing that you want is for that company to focus on the challenges of competition in that market. So like no matter who you are, whatever superstar you are in the field, if you're getting a company off the ground, you're competing with Meta and Google and OpenAI and Anthropic and Microsoft. That is challenging competition. And at the point where you've raised a lot of money, or you've like started to bring in employees, I don't think that necessarily correlates to a situation where we'd want that company to be diverting those resources away from product development and toward compliance costs. I guess like it might be that you would say, no, that's wrong. We do want that firm to do that. My thought is just, okay, but that comes at a cost. We'll have less competitive markets if that's the direction that we want to go in.
I'm playing a ton of devil's advocate here, in which I'm latching onto the fact that I think there is a potential disconnect between the hype in the industry and the reality, where the hype may actually be giving fodder for the doomer faction or the slowdown faction.
Yeah.
So
I think that's fair, but like, the one of the, again, like there are disconnects I can't explain to you. So like the moratorium has written into it a generally applicable law exception. And there are a ton of people saying this won't cover the application of generally applicable law to cases where AI is involved. That literally does not match the text of the statute. And actually, at one point, someone asked me, "Do you have any material that makes this point clearer?" And I said, "Sure, I have the text of the proposal." And they were like, "No, people don't want the text; they want other material." And I was like, I don't know what to tell you. Like, the text is the text. That is what a court's going to interpret. So this is like, we should rely on the text. Another disconnect that I don't understand is this idea that people who are bullish on the technology, like the optimists, just want no regulation. And maybe that's true for other firms. It's totally possible. That is typically a view that's associated with our firm, with Andreessen Horowitz, and it doesn't match the reality of our position at all. And I don't quite understand the reason for the disconnect. We don't want an unregulated world. So in our world, like our funds have a 10-year life cycle. So that's actually like pretty long term. Like if you were an investor in our fund, you would expect payout over a 10-year period. That's longer than like the equity vesting cycle for most consumer oriented tech firms, which is 4 years. And so if you have that 10-year life cycle in mind, that means we can't have an awesome AI market for 2 years and then have horrible, horrific technology launched on the universe in a way that people are terrified. It's scary. There are, use case after use case where people are really harmed and the law is not taking account of it. And then the market tanks. That's not a situation that works for us. Like, we're not kind of looking to get in and out of the market over a 6-month period or something. We're looking to build really strong, sustainable markets. And in order to build strong, sustainable markets, you need to have technology that people like, and you need to have laws that punish perpetrators. Like, it's not a world where just total deregulation works. And so maybe there's disagreement about the right way to get there and like where to put the burdens and how to go about it. But I don't think this is a situation where the optimists, or I shouldn't speak for all optimists, but for us as optimists, this isn't a situation where we're saying we're optimistic about the future of the technology and therefore the right governance structure is nothing. That's not the case.
That's a good segue into, okay, there needs to be some kind of rules. I will float us back up to the federal level. I do know an optimist or two who push hard for, in essence, federal preemption and replace it with nothing. People who feel that position quite strongly, actually. I'm sorry to say, I don't think that is a political winner. And I think the tech industry writ large has put itself maybe in a poor position as this debate goes forward. The alarm bell is always rung. Regulation will stifle growth. Be very careful. It tends to drift towards you cannot regulate. And you put that on right here on one side. And then on the other, there's this repeated failure by Congress to regulate in the realm of tech. It's not a total failure, but it is definitely a mostly failure. And so anybody who is looking for greater regulation, one of the real fatal flaws with the moratorium was a talking point became, put in the moratorium, it will give Congress a chance to regulate and come up with rules that will give them breathing space. And that's just ridiculous. Like, if you're on the other side of this debate, you are not going to trust that as far as you can throw it, because you're going to look at Congress's track record and you're going to say, yeah, right. Look at how privacy regulation has gone down in flames time and time and time again. So it is hard, given this history, to come in and say, no, we're serious. We want federal preemption with some kind of basic ground rules. We mean it. That's actually what we're looking for. The debate is slightly poisoned. I could flip around and go the other way and talk about the position on the other side that is, we won't do any kind of federal regulation unless it's a floor rather than a ceiling, thus not solving anything, because then the 50 states can still do whatever they want. That's another dynamic in the privacy realm. That's kind of a lot. Point being, federal framework what are you looking for in that realm, and what is an actual colorable strategy to getting people to the table to make a deal?
Yeah, so I'd love to talk about the content of that, but just to sort of take on the premise a little bit, this is something that I don't fully understand, which is that even if you think that Congress will do absolutely nothing, it doesn't mean that states can do whatever they want. States do not have free reign to take whatever action governing AI that they want to. And there have been debates about like the extent to which the model that some of the states have used is an EU oriented model. I think it's not in terms of exact, like if you were looking at the exact text, it's not exactly the same thing. But several of the states have introduced a model that is basically like it requires an assessment of the level of risk. Are you high risk? Are you low risk? If you're more in the high risk category, then you have to do a variety of different things, impact assessments, sometimes audits, sometimes you have a duty of care. You might not be able to deploy models in certain situations. And that general framework has the same elements and structure that the EU AI Act does. The EU AI Act was not just a national level framework, it's a regional economic bloc, a bloc made up of nations. It's a framework at that level of governance. It seems to me like that's not the right role for states to play, adopting a regional governance framework as the as like how Texas or Florida or what New York or California, whatever the state is, should govern the development of AI within the United States. So I think there are sort of separate questions of like, I don't think it is the case that whether or not Congress acts, that does not mean that states can just assume a congressional role. There's a separate question then of like, well, what would we want to see? What would we want to see states do? What would we want to see Congress do? And I think there's a lot that Congress could do. I mean, our point of view is that AI is not an exception to existing law. So if you use AI to violate consumer protection law, civil rights law, criminal law, antitrust law, the fact that you used AI shouldn't be something that you can use as a defense in litigation. And there are ways that you can codify that by statute. And Corbin, you've talked a lot about like the general concerns that people have. And I think that's one way to be responsive to those. There is a whole bunch that you can do. People are also concerned about workforce disruption. There's like a lot that you could do, I think, in worker retraining programs, studying labor disruption to sort of position the government well to help people transition to an AI-oriented economy. Same with literacy, for instance, AI literacy. One thing that has been top of mind for us, because of the position that we have in the ecosystem, is how could you look at lowering some of the barriers to entry that exist in this ecosystem? And you could do that not just for startups, but for researchers. You could do it in ways that like help government agencies to produce more. And the thing that we propose is a national AI competitiveness institute that would provide some access to compute and data and make it a little bit easier for a range of different actors in the ecosystem to build technology. The one other thing that has been part of the proposals that we've suggested is some level of transparency. And again, you know First Amendment doctrine a lot better than I do, but there are a lot of disclosure requirements that have been introduced at the federal and state level that I think are inconsistent with what I understand First Amendment doctrine to be. Again,
can I actually just pause you there?
Yeah.
Because one thing we've recently learned in Free Speech Coalition versus Paxton, and I'm not going to stop to unpack all of this. Suffice it to say, there are areas of law, in this instance, it's adult content, where the First Amendment may look like it says one thing, and you feel you're on solid ground, and you wave that case law around. And the state of technology, from everything from the rise of the smartphone to the state of what's on the internet and now AI, is moving enough that people are freaking out, including people in black robes, and all bets are off about the actual state of the rules. And so I can go off on a rant about how correct you are about the First Amendment currently under the Zouderer standard and the compelled speech, but I don't find that convincing right now. I feel like anybody who's going to talk about disclosures and transparency in AI needs to start with, why is this a bad idea? And then fall back to the law. That's my vibe at the moment on this.
Maybe. I mean, you have a better sense, I think, of litigation than I do, but my thought is, until you know the law is different, you assume the law is the way the law is. So I think the best the way that we would have described the state of the law and reproductive rights 5 years ago is different than how we describe it today. And I think it's correct to describe it the way we would have 5 years ago, and then
what
to
I'm saying
update
is
it to the current law today.
I'll spot you a strong First Amendment law, but I think anybody invoking the First Amendment in the realm of technology right now also needs to say why that law should stay the way it is. That's what I'm saying.
Yeah. So again, I mean, I think you can talk about First Amendment principles in more detail and more effectively than I can. But my sense of the underlying idea animating those principles is we don't want to burden the ecosystem generally. And I think that's when you talk about burdens, you're talking about entities that have fewer resources to devote to managing those burdens than others. We don't want to burden those parts of the ecosystem with disclosure requirements that are speculative, that are controversial, that are subjective. And a lot of the requirements, I think, related to like safety testing, some of the bias testing stuff, it seems exactly like that. And we've seen, I mean, I get your point about the law shifting, but we saw two pretty convincing Ninth Circuit cases in the last, I think, year and a half about the kinds of disclosures that I think some people are pushing for in the AI space. And with courts saying in some of those cases, like, there's a lot here we don't know about, but we know this thing is clearly unconstitutional. I get your point that in 5 years, maybe we'll be in a different place. But I think as of today, we should like think of the law as it is, and, you know, maybe it will change. And from our standpoint, it's again, I mean, it's kind of like thinking about development versus harms. Like in this space, it's not just that we think it's unconstitutional, it's that we think a lot of the disclosure requirements aren't very useful for consumers. Like they don't give consumers information that will enable them to make like smart, informed, actionable decisions. And so we also suggest that the federal government and state governments could do it too. Have a limited, like think about a limited disclosure, compelled disclosure framework. That's more, we call it AI model facts. It's more of like, what are a set of things that if you disclose them to consumers, it will enable them to make more informed decisions. And like one of the things in there, which I've not seen part of any policy proposal, oddly enough, is to require a model developer to disclose the knowledge date cutoff of its underlying training data, because that will enable you to understand like what are the set of events that this model is likely to take account of, and what are recent events, as of what date would more recent events be less likely to be something that this model could take into account. That's something that is like, I don't think that's like a sexy policy proposal. I can understand why maybe like certain people who want to see certain things haven't included that. But in terms of like, can Corbin and I use models effectively? And do we understand going into our model usage? Do we have a sense of what reasonably we can expect from what the outputs are? Like that's the kind of data that I think is really useful. And I guess to your point of like, thinking about the underlying equities of a transparency mandate, I think that's the kind of data that is a little bit closer to something that's credible to argue that it really helps consumers to understand the technology they're using.
Sticking with Congress, and this goes to the vibes. Sorry, I'm back on it. You've mentioned some excellent ideas. Just yesterday, we got the AI action plan out of the Trump administration and some executive orders. That plan has good stuff, much of it in line with the kind of stuff you're talking about in terms of literacy or worker training. But there's really only so much the pen and the phone you can do as the president. I promised you I wouldn't grill you on the plan because it just dropped yesterday. But actually, It also is a little bit of a sideshow to the conversation that I'm interested in, because no matter what the president does, we need the perception of AI to be positive enough, in my mind, for Congress not only to do things that are sort of orthogonal, sort of nobody pays a price. Everybody's fine with spending money on worker training, but where are the things that actually require real congressional reform? The FDA being a big example. The FDA does not seem designed for an AI world. You need Congress to actually pass legislation. We potentially run into problems with energy, with healthcare, the possibility being that no matter how good the AI gets, we run into all of these obstacles and bottlenecks in the real world. So it's not just that we need people to resist the urge to whatever, go with the models. We actually need Congress to be willing to take proactive measures to do things that a lot of people are just going to yell like it's deregulation to keep from throttling this technology. What are your thoughts on that?
I mean, we again like the right AI governance is not no AI governance from our perspective, and so I think the idea of a federal legislative framework is a really positive one. I think you're certainly right to say like there's limits to what the executive branch can do, and whatever you think of the AI action plan, we really want congressional activity, but there are really good things in it, and things that really like have a meaningful impact on people's lives. And I think there'll be a range of views of what's good and what's bad in it. I think, but I for better or worse now wake up in the middle of the night or very early in the morning thinking about AI policy. I guess it comes with the job, and like the thing that I thought they like lightning bolt in my head when I woke up early this morning was the stuff that the Department of Labor will do. I think will like be meaningful for people. Like it will improve their lives in tangible ways. And maybe I'm wrong about that. And maybe we would all want to see much more happen through legislation. But I think it's a serious attempt to like really to think about worker retraining programs, to have metrics that matter for evaluating labor disruptions. And I think those are meaningful steps. I mean, you said a few minutes ago, like I'll roughly paraphrase, like, what if models do horrific, terrible, terrible things? And what can we do to prepare for that? And I think it's conceivable that there are negative labor market disruptions. It's conceivable there's a lot of positive labor market disruption. We don't really know, but it is important for us to know, to start to see those trends when they develop, and ideally to see them as quickly as possible. And so having the Department of Labor be focused on developing metrics that help us to see that stuff more clearly, I think is really meaningful. So I think it's positive, and also it would be great to see federal legislation that does some of the stuff that we were talking about a few minutes ago.
I have been, yes, adopting what you might call doomer talking points. A lot of them are not necessarily my talking points that I actually believe, but they're not illogical. There is an intuitiveness to a lot of these. Do you view, I mean, it seems to be part of what Andreessen Horowitz is hoping to do. I don't know if it's you personally who has this job, but how do you do a better job of making the positive case and assuaging some of these fears? I mean, we talked about transparency a moment ago, and you can say, well, there should be something akin to a nutrition facts on the product you're using. That's all well and good. I think the fear some people are actually having is, no, we need transparency around, is the model going how? Is it trying to break out of its constraints? Is it doing things to try to, is it making up its own language to talk with another LLM that nobody understands? Those kinds of things. And that is brought out because of these underlying fears that if left to fester. I mean, I didn't come here armed with exact poll figures, partly because polls are kind of stupid. You ask people, should AI be safe? Like, yeah, oh my God, 90% of people agree. But there is something there. You look, I saw one, not that I trust polls out of China either, but it had us as mirror images where, 75% of the people polled in China are excited about AI. And it's almost the opposite in the United States. And there's a big majority who actually says we should pause or slow down the technology. It just seems like underneath the water, there is this potential huge political backlash if we don't do everything to right size the narrative. And so I swing it to you. Do you have thoughts on that? Is there a strategy on that?
I mean, I think I have to answer yes. Like, of course, there's a strategy. Our job is to have my job is to have a strategy. I think I started this job in November, and I wasn't exactly knowing what to expect. I think the extraordinary thing about it is that I feel like and again, like lots of people would disagree, but I think the stuff that the positions that we've articulated in AI policy feel to me like, in theory at least, they should be like optimist doomer agnostic and right left agnostic. Like the idea is, how do we create a competitive AI market and also address harms that people have, address concerns that people have about harms, address their like real underlying concerns. And I worked in my career, I worked at Facebook, and then I had a 5-year period in academia, and then I came back into industry in November. And one of the things I sort of like remembered, but it doesn't I've sort of lost the tangible feeling of it is the sort of ad hominem nature of some of the attacks between these various different communities. And I have tried imperfectly, I think, but really tried to think of people in these debates as acting in good faith. There's a bill in New York that we think is really problematic. There's a bill in California that we think is problematic from a little tech perspective. But my sense is that the proponents of those pieces of legislation are acting in good faith. They think that they are taking steps that are important to take to protect people from harms, and they think they're doing it in the right way. And I'm trying to approach these discussions not from the idea of like undercutting motives or like pretending as if they are acting in some way that is like intentionally nefarious, but instead to think of like the entire enterprise as focused on a set of ideas and a set of problems that are somewhat universal, and that we're working in somewhat different ways to figure out the right path on solutions. And I think if we, I mean, I know it sounds like sort of naive, I guess, but I think if we do it effectively, like hopefully we're being responsive to those concerns. I don't think our position that, if you violate federal or state civil rights law, like is that hostile to doomers? Is that hostile to the right? Is it hostile to the left? I mean, civil rights law in theory would encompass concerns about bias, and some concerns about bias, and would also address concerns around censorship in theory. And so I think those kinds of principles, hopefully they kind of like sit above some of the fractures that we're seeing. I mean, to your point about the moratorium, I wouldn't say that debate like created the idea that there is, that there's a shared sense of working together to address hard problems. That was a debate that really like was focused on fractures, but hopefully that's not the case in every AI policy debate.
I'm going to have to skip the conversation that itself would be 1 hour of working out exactly how civil rights law and AI interact. What I will instead ask you, because it is the Tech in the Courts series, I got to ask you something about tech in the courts, right?
Yeah.
What lawsuit vectors do you see that are grabbing your attention? Either things that have already been filed or things that are when you're thinking about AI at night, as I think you said you do, maybe pop into your head.
Yeah. So, I mean, I think First Amendment stuff, obviously, like I'll be interested if there are compelled disclosure cases in AI. I think obviously copyright is another key issue. We haven't talked about that one, but it's one of the larger issues facing the industry. And there are, I think,
another hour conversation all by itself. Yes.
Yeah, I think there are roughly 40 cases that are currently pending, and that how those cases are resolved is really going to have a significant impact on the future of the sector, including I think how the sector will look from a little tech perspective. So I think that's key as well. Are there you track litigation closely? What are the other key ones? What are the key ones that I'm missing?
On the last episode of the Tech Policy Podcast, we talked at length about the Complexity AI lawsuit.
Yes,
the chatbot and the tragic suicide.
Character AI.
What did I say?
Yeah, complexity. Yeah.
Sorry. Character AI.
Company complexity. Yeah.
And then now we're dealing with defamation here on the Tech Policy Podcast. No, character AI. Yes. Is the one I would throw in there. Although I would instead just direct everyone to our previous episode.
Yeah. Interesting.
Couple extra minutes. So I'll ask you one just that caught my attention. Listening to Mark Andreessen, and he said that you guys invest on the assumption that AI is going to get it right. Investing on the assumption that in the AI revolution, all the incumbents are going to get nuked. And he didn't mean it literally. It's the investing strategy. It's not literally true. Nonetheless, that was a very interesting statement, and I was wondering if you could channel your inner Mark Andreessen for a moment and tell me what.
Yeah, he's one of a kind, so I'm not going to try. But I think it goes back to what I was saying before, which is there are visions of AI, and I think it's been pretty like explicitly articulated, like in the EU AI Act conversations. It was articulated in that context. I think when you look at some of the ways that these discussions have unfolded in the United States, like the initial voluntary framework that the Biden administration agreed to with a set of companies. It was worked out in a private meeting with I think maybe 5 companies. It was a very small group of companies. There is an idea that this is going to be an area of technology that is in the hands of a few, and the government is going to sort of play a role, a tightly controlling role on regulating those people who are those companies that are operating at the frontier. And it's conceivable it could, maybe it plays out that way. That's possible. I think the investing philosophy, as you said, is that it won't be that way. That this is a world where the most exciting new technologies are ones that we don't yet, or like exciting new technologies, but also companies and products are ones that we don't know yet. The household names in 10 years are companies that are not household names today. And I think that's the concept that Mark is getting at, that this is a world of this ripe for disruption. He said, I've heard him say in several different contexts, that the pace and level of innovation in this area is steeper, faster, more aggressive than any he's seen, including the dawn of the internet. And that's a massive thing. Like, that's not a thing to take for granted. That's a massive thing. And I think where it leads is that there's a lot of opportunity for real disruption and creation of new exciting tools. And that's why, going back to kind of the early part of our conversation, that's why we are so focused on ensuring that those little tech companies are able to explore their ability to create competitive, interesting, compelling nuking tools.
This has been the latest installment of the WLF Tech Freedom Tech in the Courts series. It has also been the Tech Policy Podcast. I'm Corbin Barthold, been joined by Matt Perault, head of AI policy at Andreessen Horowitz. Matt, this has been a real pleasure. I really appreciate your time.
This is fantastic. Thank you.
Thank you, sir. And I will hand it back to Glenn.
Thank you both for joining us today. It was a real pleasure to listen to both of you talk about this, and I hope that all of our viewers learned as much as I did from both Corbin and Matt. If you have a chance when you sign off from the broadcast, there'll be a very short survey. You could fill that out. And again, thank you everyone for joining us, and hope you have a good rest of the day.
Thank you, Matt. This was great.